You're now recognized for 5 minutes for your remarks.
Thank you, Chair Wagner, Ranking Member Sherman, and members of the committee for the opportunity to testify today. The ASA is a trade association of American financial services firms whose mission is to promote investor trust and confidence and support competitively balanced financial markets. And we strongly support the SEC returning to the mission that Congress gave it. Congress created the SEC in the wake of the 1929 stock market crash to restore Americans' faith in our capital markets. And for much of its history, the SEC did just that, becoming the world's preeminent securities regulator. However, since the 2008 financial crisis, a concerning trend has emerged. The SEC has increasingly acted outside the scope of its authority to pursue partisan political policies. The pendulum on hot-button political and cultural issues has swung from administration to administration, and this has turned the historically apolitical and technocratic agency into an unelected political actor. This injection of politics into our capital markets has created uncertainty for companies and their shareholders, and it's led to a multi-year transfer of wealth from American investors to a professional class that profits from unauthorized regulation. The SEC needs to be an objective regulator focused solely on its statutory mission, not one that caters to special interests, regardless of where they sit on the political spectrum. Congress can end the SEC's mission drift by reasserting its policy-making prerogative over the agency. By that, I mean, if Congress cannot agree on the details of a policy issue, then language about that policy should not be in the legislation, and the legislation should not include broad, opaque, or public interest language that allows unelected individuals to make policy decisions. Congress's delegation of its power to the administrative state has gone too far for too long, and it's the central reason the agency has become so politicized. If Congress doesn't reclaim its power now, then it risks sending letters that go unanswered and complaining about policies it didn't authorize, and that's certainly not what the framers envisioned when they gave you the power to make law. Now I'll briefly summarize the rest of my testimony. First, the Commission's delegation of policymaking authority to career staff must end. This is appropriate solely for administrative matters, but not policy decisions. Second, career staff must obtain Commission approval to initiate industry-wide sweeps. This power is too great to be delegated to unaccountable career staff. Third, the public deserves a minimum 60-day comment period for rule proposals and at least 90 for complex rules. Fourth, the SEC needs to publish a transparent fine schedule for administrative rule violations such as record keeping, so the public understands how fines are calculated. Fifth, enforcement staff must be held to the same ethical standard as every other licensed attorney. Having staff sanctioned for lying to federal courts and having to dismiss dozens of cases because staff acted improperly erodes the public trust in the agency. To change this, senior leadership in the enforcement division should have securities experience, not just prosecutor experience. Sixth, SEC rules must respect cost-benefit analysis that Congress required. Using random, unjustified costs and saying, quote, "We are unable to reliably quantify the potential benefits and costs of a rule," end quote, is unacceptable. This disregards a congressional directive specifically designed to stop unjustified rules from harming the economy. Seventh, SEC rules must be authorized by Congress. The public should not be subject to a comply or sue scenario. Lawsuits are costly, and repeated court losses damage the agency's credibility. Eighth, rule filings from FINRA and the MSRB should be sent directly to the Commission. They should not be subject to pre-negotiated sign-offs by career staff before going to the commissioners. Ninth, the SEC's unauthorized delegation of its core functions to SROs must end. These delegations circumvent the appropriations process, and they impose open-ended costs on the industry that should be on the agency's budget. An example of this is the SEC's delegation of CAT to the SROs, which required the industry to fund a multi-billion-dollar regulatory surveillance scheme that illegally collects the personal and financial information of every American investor. 10th, Congress should revisit the current structure of the agency to insulate it from partisan political pressure. And while there are many ideas, one might be that the Commission should be evenly divided with permanent co-chairs, one from each party. Thank you again for the privilege of testifying today, and I look forward to taking your questions.
I thank you, Mr. Iacovella.